Hi, everyone. Today we're going to be talking about the public charge rule that just got announced. We knew it was coming, and so let's really talk about it. Trump 1.0, first presidency, wanted to upend the public charge system. For better or for worse, he believes this is better for America. But the 2019 got stopped. It got revived in 2022 under Biden for a more lenient version. But now the 2025 public charge version has been released. We are in public comment phase, and then it's going to be implemented by USCIS, and then we will start seeing fresh new denials based on the new public charge rule. So today in the news segment, I want to talk about the public charge rule. What does that mean, and how can you prepare for your adjustment of status, and also non-immigrant visas as well, right? And this also applies to business immigration too. A lot of people think public charge is only a family immigration issue. It isn't. Inadmissibility is an inadmissibility. If you are a public charge to the United States, just because you got the green card application process submitted from the business immigration, it doesn't mean your green card cannot be denied, okay? So we're gonna go through that. And then the success story today is gonna be about EB1C. It's about being an executive and getting the green card. This case was quite complicated. It got denied last year. It got a request for evidence. It got denied last year. We refiled it this year, and then it got approved. It was done by a different firm in Canada, and it was some of the most bizarre requests for evidence that we've seen, but we were able to refile it. It got approved. So we're going to walk through all of that, and we're also live answering questions. So if you have any questions about immigration, feel free to reach out. Feel free to ask. Galen here will be asking questions in different intervals, but we're going to start with the main news segment, which is the public charge, because we've been waiting for it. We knew it was coming, and now it dropped. So first of all, let's talk about what is public charge. In so many words, it essentially means if you are too poor and the United States will likely have to support you, you are not self-sufficient, then you don't deserve a green card. This law has been on the books since the 1800s. Every country in the world has some versions of it. The latest version we had was from 1999, and it's been carrying all the way up to 2019. And Trump 1.0 wanted to upend that entire system and say, no, we were too lenient on the old public charge standard. Let's up it significantly. There was a lot of litigation around it. It got stopped in 2022. Biden's public charge rule came out. It was a little stricter than the 1999 version, but it is nowhere as strict as the 2019 Trump 1.0 version. And now in 2025, the newest public charge rule just got dropped. It's up for public comments, and it is far stricter than the 2019 version. So I think I want to start by saying who doesn't need to worry about it. Okay, let's start with that. If you fit these kind of criteria, most likely this new public charge rule would not affect you. So here's the statutory factors that every government officer is supposed to be reviewing. And then there's other ones. But this is based on the newest public charge rule. If you fit into these requirements, all of them, then most likely you don't have to be concerned. So if you are a non-immigrant, if you are trying to get your green card and you are between the ages of 18 to 61 years old, your age, you are in your quote-unquote prime working years, most likely you might be okay because you will probably be working, right? And so you'll be contributing to the economy. But let's say you're a U.S. citizen petitioning your parent, and your parent is 62, 63, 65, they've already retired, then you might be concerned. So the second thing, how's your health? If you're in prime health condition, you don't have any major disease, you don't have any major conditions where you might be unable to work in the future, then you might be okay. So your health records needs to show that you will be able to continue working, and there's nothing that's going to be stopping you from being able to work. That's the second thing. The third thing, your family condition, your family status. How many family members do you have? If you're single and you're working, okay, most likely you're not going to be a public debt. You're not going to be a public charge. But if you are applying for a green card and your whole family is following you to apply for a green card, and you have a family of 5, family of 7, and your income is too low, that might be a bad situation. So your family status, how many people in your family they're working. And here I want to pause a little bit and talk about the 2025 public charge rule, because it doesn't just look at you anymore. The 2019 version, the 22 and 22 version, they focus mostly on you. Were you a public charge? But now they also look at your family members. If your children use public benefits, you're applying for a green card. Well, that might mean you are not able to support them. So I'm gonna go through the first 5 and then we'll start answering questions, because there's more. I know there's more conditions as well. So again, repeating the first 3, your age, your health conditions, your medical conditions. Third is your family size, your family situation. The fourth is your financial assets. That's the most obvious one. How much do you have in your bank? How much do you have in your stocks? Do you have a retirement plan? What is your savings? Do you have a mortgage? Do you have a house, right? Your current financial situation. If you are rich, even if you're old, even if you're a medical condition, well, most likely you'll be fine. So that's the fourth one. How's your family, your financial situation? And the last one is your education and career. Maybe you don't have a lot of assets, but you're highly educated and you have a job and you have continuously have a job. Then that's most likely 5. That's the statutory 5 things that they must look at. And so that's the most important. But the 2019 version, the 2022 version, they start chipping away at some of the other things now. So maybe you have these 5, but now USCIS, they might have the authority to still deny your case. So let's go through it again, right? Public charge, if you're too poor, the government doesn't want to give you a green card. The first, they look at your age. The second, they look at your health. The third, they look at your family size. The fourth, they look at your assets. Then they look at your career opportunity. If none of these 5 apply to you, you're passing with flying colors. However, one of the craziest things about this new 2025 version of the public charge is that they are saying those 5 statutory requirements should be the minimum. Every single officer should adjudicate each case on a case-by-case basis. They should take into all things and they should be able to adjudicate. And so they're removing the bright line test. These are 5 bright lines. The 2022 version gave additional bright lines, as a bright line test is a clear pass or no pass. So just again, to be clear, since 1999 and the 2022 version that are official guiding laws that govern public charge, it has always been bright line, which means there has been very few denials on the public charge. All right, we're talking like double digits out of the whole year, right? Just very, very little denials. Like if you're a U.S. citizen that petitioned your spouse, your parents, your sibling, if a job gave you a EB2 or EB3, most likely your case will have gotten approved in the past 5, 10, 20 years if you meet all the other requirements. Public charge is not a big reason to be denied. However, this administration and the public charge, and since 2019 till now, they really looked at it and say, no, it shouldn't be. There's a lot of people who got green cards who they think are a public charge. They think they are a leech on society. They think they are drawing benefits as opposed to contributing to the economy. And so they think that number should be far higher. I don't know if you agree or disagree on that, but that is the state that we are in. And so in 2025 memo, above these 5 requirements, they're also saying we look at everything now. So every officer can look at everything and adjudicate it. And that is why historically business immigration firms like ourselves didn't have to worry about public charge, because regardless of the policy change, it doesn't really affect our clients. They have a job, they have an income, they're not a public charge. But here's the situation, right? Let's say you are an EB1A candidate. You are, one of those genius visa categories, right? Or EB2. You are self-petitioning. You are amazing. You're an amazing poet from overseas, and you're coming to the U.S. You have a family of 5. You're extraordinary in your field, but it's not a high-paying field, right? Maybe you're just writing poetry. You won a bunch of awards, but doesn't mean you have a high income. And because of your years of work, you're already 60, you're already 70. It took you that long to become a Nobel laureate. Now coming to the US, you don't have the income, your age, you might have some health issues, and you have a large family, And if other people don't work, now USCIS can deny you on public charge. This is a business immigration case. Or EB3, you're a chef, you're a gardener, you're a dishwasher, right? You work in a farm. Okay, you got your case approved. We demonstrated that there's no U.S. workers that want these jobs, so you deserve a green card. However, you come from a country, a family background of, again, you have a family of 5 or 6 people, and everybody relies on you, but you only make $30,000 a year. You're a public charge because based on the federal poverty guidelines, you don't make enough to support your family. Even though you're in the business space, traditionally, you don't need a joint sponsor. Well, in this day and age with 2025 memo, EB3s might be denied. EB1s might be denied, right? EB5s probably not, but still, so this new memo takes away the bright line policy that we've had for decades, where we can clearly see this person qualifies, this person does not qualify, and the denial rates have been very low. Now, going into the future, next year, next 10 years, we are going to see a lot more of these. So let's talk about what you can do to prepare for your case. So here's additional factors that they're not looking into. Have you used any government subsidies? And so all the debate that you're going to see online between the 2019 version, the 22 version, and 2025 version is over the details of it. How long did you use it for? Was it 19 months? Was it 36 months? Are you proven that you're dependent on government subsidies? Is it a federal or is it a state? Is it a local institution that giving it out of the goodness of their heart? Is it a cash benefit program or is it not cash benefit program? You're going to see all the debate around that. Here's the main thing. The 2025 version says that the officer can look holistically at everything. So even if it is quote unquote sanctioned, even if it's quote unquote allowed, they'll still see that as, how can your children and you use all these different government programs? Well, that kind of tells us that you're not wealthy enough to be in the country to get a green card. Section 8, rental assistance housing. You're using, God forbid, a bunch of different coupons. They say, wow, you have to use coupons, you have to use food stamps, you have to use these benefits, off and on. That kind of tells us that you don't qualify. This area of law is changing by the day. It is because it's a case-by-case basis. What that's going to mean is going to be each different field office. New York is going to adjudicate it completely differently than Texas, than Oregon, than California. Okay, different populations. A lot of Asians are here in Southern California. Not a lot of Asians in Florida. Florida have different population with different needs, with different patterns of behavior. Every field office is going to adjudicate these cases differently because of the public charge rule. When you remove the bright line test and you say everything is case by case, that means every officer is going to do it their own way. So regardless of what you see, these public benefits are okay. They might have been okay under the 2022 rule, under Biden's rule, it might have been okay. But now under 2025 rule, because it's a catch-all, it might not be okay anymore. So that's the thing to think about. And that is the 100% intent. Let me show you, okay? Oh, I can't show you the case. Okay, let me show you. This was the public charge memo, discussion, teaching by one of my favorite organizations, Immigration Legal Resource Center, one of the best. This is not a commercial, by the way. They did not endorse this, but this was the policy pre-2019, okay? What is it? 140 pages in big font with sample. Easy peasy, not an issue. Once 2019 came out, this is their version, okay? How many pages? Over 500 pages dissecting the 2019 memo under Trump 1.0. 22, we didn't get a book because it made the 2019 easier. So if you know this, then you don't have to worry about, it. And we've seen from 2019 all the way till the present, very few cases got denied on public charge. None of our cases got denied on public charge. Now, this is the law that came out yesterday talking about the new memo that they plan on releasing. The next IRC book that's going to come out addressing it is probably going to be like 800 pages, And so it is complicated. It is difficult. If you haven't been able to hold down a job, do that, because not being able to hold down a job and switching between jobs constantly and being able to work but not working is a big negative factor in the new policy. Having joint sponsors, right? So maybe you never had to think about a joint sponsor because everything we said earlier, because you're maybe on the employment status side. Well, maybe consider, well, can I find a joint sponsor, somebody who can guarantee that I will not be indebted, I will not collect food stamps, right? Maybe you never had to do that before, maybe nobody ever, but just keep that in your back pocket, right? Ask a friend, a favor, a family member that they could be a joint sponsor, right? If you're in a family situation and you already have joint sponsor, but it's not sufficient, right? Oh, that's, by the way, a lot of people think, isn't public charge, you just have to get a joint sponsor, and if you have a joint sponsor and they make enough, then it's fine. No. Having a joint sponsor is just one of the factors, right? So it's like, maybe you're young enough, maybe you have high enough education, maybe you have enough assets, maybe you have enough finances, and having joint sponsor is just part of that finance part. But if you have a severely disabling medical problem with a bad history of tax returns, having a joint sponsor might not be sufficient. It's just a factor. You might say, that's insane. I agree. But that was the bright line test we had in the past. And now getting rid of the bright line, even if you have joint sponsor, might not be sufficient. Well, then get 2 joint sponsors. We've done cases where we had 3 joint sponsors, right? So it's a lot of work, obviously, but getting more joint sponsors, getting a job, starting a company, even if the company's not doing well, at least you show your ambition, right? So there's a lot of things that you can do. Be a part of a nonprofit, get your expenses covered, have health insurance. These are all things that will really help. And you might be saying, easy for you to say, right? I mean, the only reason we're dealing with this public charge is because we can't get a job, because we can't get health insurance, and health insurance is just so expensive. So look large and spread wide to really figure out what nonprofit that you can work in, and maybe they can help with some of the basic health insurance, right? And so this administration is really making people work for it, for making U.S. citizens, in order to collect benefits, they have to work. For people who are not green card holders yet, who are applying for green cards, and if you don't make enough, they're making you work for it. So that's a new public charge rule that I have been doing a lot of consultations on. Right when this came out, a lot of questions, and I just want to consolidate everything, share it. We're going to find out new information out there. It's really confusing, but I hope this helps. Right, so we're going to talk a little bit more about that, but I know we have questions, so I'll answer questions now.
Yeah, have you ever helped a minor green card holder re-enter after too long absence with just a consultation?
Yes, we have. Multiple Russians. I remember it very distinctly. It was a very complicated situation a few years ago, and this was when Russia just invaded Ukraine, and we're doing a lot of helping a lot of kids get back into the U.S. from all over the world, but we haven't done a Russian case, and they I think left the U.S. for over 6 years at the time. It was complicated. We didn't feel like it was a likelihood of success, so we didn't want to take on the case, charge in their kids, and so we said, here, let's do our best. We'll give you the consultation, we'll teach you everything, and just try, right? You can try yourself, we'll teach you the methods. And then they came in successfully, So, and it's not just because they're Russian that we did the consultation, right? We happily use our consultation to help everyone as long as we know, right? So, for example, if you have an asylum case, if you have a U visa case, we just don't have enough expertise to teach and help. But if you're a green card outside of the U.S., you want to come back in, happy to explain. If you're going through a difficult LCA H-1B process, we're here to share our knowledge to help you, right? It's not a sales pitch. We're just trying to share as much as we can. Now, if afterwards you're like, that's too complicated, you still want to hire us, great, right? But again, we're not, the consultation is here for you.
And yeah, so this is the person who their parents can't come in because they're taking care of their grandma. The minor is staying with a family friend. And I'm also wondering, what specifically do we talk about in the consultation that would help them actually re-enter?
I mean, I think most people just don't know the logistics. What's the best case scenario? What's the worst case scenario? How to deal with certain situations? What's the logistics? Do you just buy a plane ticket and fly in? How do you explain the situation? What documents to bring? I mean, if you really want to categorically from a top level down, we talk about, all the different strategies. We talk about all the different checklists. In your situation, so I can talk about it generally. We made other videos, like 140 things you could bring, but your situation might be different. And so we go through and I'll help you come up with a checklist. We talk about the timeline. When's the best time to come? Not a good time to come. When should you do it, right? We talk about, yeah, I mean, those are probably the most main things that people want to know during the consultation.
And why are they only targeting Hispanics? Immigrants are from everywhere.
Are you talking about ICE right now? Is this a separate question?
Yeah, separate question.
I can assure you they are not just targeting Hispanics. I can assure you of that. Why? Because I'm an immigration lawyer. I go to immigration conferences. I speak with other Indian immigration lawyers. I speak with Korean immigration lawyers. I speak with people from all aspects of the world. And I could tell you for sure, consulates around the world, ICE, people have been detained. It's not just Hispanics. In your bubble, what you're seeing might be Hispanics because there's more Hispanics in the United States than any other ethnicity. But does that mean a Cambodian is not being harassed? Absolutely not. Does that mean Korean army officials are not being deported? Absolutely not.
And do you also help by email after the consultation if we still have questions, assuming they don't sign the retainer?
No. Our best thing is just to serve and help during the consultation, right? Or else, I'm just trying to block out as much time as I can to help as many people as I can. And so during the consultations, I have to help you. After consultation, I have to help somebody else.
I got approval for EB1. I'm worried in filing my AOS because I have a misdemeanor. The court disposition says dismissal upon court fee. What can your law firm do?
There's a lot of situations like that. Now, let's just talk about worst case scenario, right? Worst case scenario, it is a disqualifying charge. I don't think it is, but it might be. Worst case scenario is you do a post-conviction relief, you reopen that criminal case, and you get it completely discharged completely. That is like, you're really pulling out the big guns to solve your problem. Most likely, it is not a deportable offense. Most likely, it is not an inadmissibility. So what you should do is you take your core records, take out your name, but take out your core records, upload it to ChatGPT, upload it to Gemini, and you ask the question, is this inadmissible? Is this going to prevent me from getting a green card? And see what online says. In the past, before AI, you have to hire a immigration attorney, review all the court documents, officially write a legal opinion. But with AI, you could do that for free. And if all the AI system says it's not inadmissible, then you are much more confident. Then you can hire an attorney and you can file the adjustment of status, right?
Someone says, highest quality live I've ever seen. Thank you. Feel free to share it or repost if you think other people would benefit. So this is a follow-up on EB1 AOS, but worried because of their misdemeanor. They say, this administration is my problem. They don't follow orders.
I want to give the benefit of the doubt to USCIS. And I know most people don't want to, but I just want to take a step back and say, there are a lot of career USCIS officers. They've been there for 10 years. They've been for 20 years. Yes, it's true that this year it's been gutted. A lot of people left, a lot of brain drain, a lot of senior good officers have left. They took out early retirement. They haven't been hiring, and new hires are not properly trained. All of that is true, but nonetheless, an administration's policy is not indicative of the entire nation. And there are good officers who are adjudicating. And the law, if it is on your side and they still deny you, that's when you take them to court, right? And so we're still in a government where we see a lot of cases get approved. And almost ironically, this year, we saw cases get approved faster and quicker with less requests for evidence for a lot of things. Things are getting stricter, but earlier in the year until now, right? And so thousands of green cards are still getting approved, right? And so really look at your case. And if you have a strong case, the only thing that's holding you back is not actually the White House, it's your fear, right? So overcome that fear, prepare well, and hopefully your case can get approved. If your case is like half, 50-50, if ChatGPT says your case is approvable, Gemini says it's not, you consult 3 different attorneys, they're all different, well then there's cause to be concerned. But if everything is on your side, then you're the only person holding yourself back.
What if we need to extend the 1-hour consultation? How much do we have to pay if we have additional questions?
Yeah. The $250 consultation, well, let me just start by saying this. I actually finished most of my consultations in 20 minutes. Okay? Just putting it out there. Almost 70% of my consultations, we end in 20 minutes because I help answer everything, right? I mean, there's only so much you can ask, and we've done hundreds of these cases. So, you know, unless you're asking a question and you're asking another question and you have other issues and we're just having a lively conversation. But most issues I actually solve in 20 minutes. So I usually don't worry about going overtime, but if the time ends, you just book another session, it's just another $250. I could assure you the $250 is our pro bono rate. The firm goes bankrupt if our only source of revenue is the $250. I'm trying to do these live sessions so I could freely give advice as much as I can. But the $250 is catered to you. And my suggestion is go check out our YouTube video. I made over probably 100 videos on LPR trying to enter the country. If you watched, you know, a third of those videos, you probably know 50-60% of everything I'm going to say in the consultation. And then during the session, I could probably tailor it to you. So that's how you can best help yourself. We are very, very transparent. So again, I made 100+ videos. Some of them are over like 20 minutes long, detailing, explaining how these cases work.
And can you say a little bit more about how to get the most out of the consultation? What should they go in with? You know, should they go in with list of questions? Should they go in with like, okay, this is what I'm going to say? How can they get the most out of these consultations?
Yeah, well, I think what you want to do is if you are already researched, just pretend I am the officer, right? Just pretend when we have the consultation, it is game day. So show me your best. Show me your absolute best. All your research with all that AI has to provide you, show me your best, and I will elevate you from there. I'll be able to directly see through, oh, you assumed this, but that's incorrect, or you thought this, but that is an assumption that hasn't been checked out. So show me what your best plan is, and I'll be able to build from there.
I'm in Texas with DACA, military daughter. Do I keep renewing my DACA, or can I apply for parole in place?
Great question. Texas has somewhat shut down DACA, at least the work permit potentially. So try to apply. It might not work. I know a lot of people in Texas who are on DACA are considering moving out of Texas to be able to file for DACA. So that's a tricky situation. Parole in place is a separate benefit compared to DACA. And so if you qualify for parole in place, of course do parole in place, because that way you could directly get the green card that way, right? And so do the parole in place. And we just did a live last week about this. A client filed for the parole in place, got denied, but luckily the parole in place said there was lawful admission, and therefore they were able to file for adjustment, and the court approved it. But short answer, if you're in Texas, you have another option. Do the other option.
Is it risky to travel on advanced parole next year?
If you have a mandatory detention under ICE, don't travel, right? So if you have drug offenses, don't travel. If you have arrest records related to drugs, don't travel. If you have no criminal issues and you're adjusting for status and you're doing advanced parole and it's a short trip, most likely it will be fine. In the Biden era, some people do adjustment status and they leave the country for 2 years under advanced parole. As long as it's valid, they come back. Here's the thing that I really want to warn you about. Really take a close look at your advanced parole. We have a client that is getting screwed over by the government right now because the whole family got an advanced parole for like 2 years, but the main applicant only got advanced parole for 3 months. That doesn't make any sense. Left the country, advanced parole expired. Now the whole family's green card is going to be denied. We're trying to fix it. It's been 2 years, no solution. We're getting this congressional support. It's very complicated. If your advanced parole is expired, you cannot come into the country, right? It's a hard stop. You need a lot of discretionary power to be able to get back in. So, is it safe to travel? Yes, unless certain situations arise. And definitely don't travel for too long because, again, you have clients who are on 751, advanced parole, leaving, and then their case gets denied. Well, they can't get back in now. So,
is it safe to use a psychological evaluation for VAWA?
of course. But I mean, I'm surprised if you don't. I mean, almost everybody do. I'm assuming your question is, can I only rely on psychological evaluation? Meaning, I don't have arrest records, I don't have court records, I don't have any other proof to show that I've been abused, and so I'm applying for VAWA just purely on a psychological evaluation. And the answer to that question, almost all attorneys will say that is a risky move. But if you have good case and then you want to add psychological evaluation on top of it, it's a bonus.
Will I be safe if an ICE agent stops me and I show them my DACA?
Here is what they will say. Okay, so let's say you are stopped and you just show them, hey, I have DACA, STFU, right? Okay, let's say you do that. I'm not saying you're going to do that, but let's say you do that. This is what the ICE agent will say. Sorry, DACA is not a defense. We can still deport you if you have DACA. You might say, no. They will say yes. And this is their line of thought and their explanation. The deferred program, DACA, is a deferred program, meaning we can deport you, it's just deferred. Okay? You are unlawfully here, we can still deport you. And it is not a defense. So if you have other inadmissible, they'll say we can even deport people who have green cards, let alone DACA. So DACA is not a defense for them to STFU. It is, however, an equity to be bailed out. So if they do pull you into detention, you could say, look, my family needs me, the US needs me, my employer needs me, please let me out. And so having a DACA lets you get out. But that's a very different attitude when you're confronting and being confronted by ICE.
Is there a backlog with USCIS?
When was there not a backlog? Ever since I started practicing, I mean, there's always been a backlog, and there will always be a backlog.
Can I apply for parole in place if I have the advanced parole legal entrance, military daughter?
Yeah, sounds good.
I'm confused about DACA in Texas. My permit just got renewed 2 days ago with my work permit.
Oh, congrats. The confusion about that is because there was a federal litigation and over DACA, and the Supreme Court, I believe, essentially says they agree with the government that DACA was an overreach and shouldn't have given DACA out, which is a pretty big blow to the executive order and to everybody who have DACA. However, they said that only Texas was able to show that it damaged their state with DACA, meaning all these people who have DACA were able to get benefits, get jobs, lower wages, and harmed the state. And therefore, only Texas, USCIS, can they now deny work permits. So DACA, you can still be in status, but you can no longer work. So I'm surprised, work permits are still being issued in Texas. Maybe it was because it was filed a long time ago. Maybe this court case is new. But at least from the immigration lawyer community in Texas, trying to renew your employment authorization is going to be a big question mark. For everywhere else outside of the country, it's still permissible until further notice.
Where are you located, and what's your legal fees if I'm to hire you? This is for the EB1 AOS with a misdemeanor.
Let's just start with the 250 consultations. We try to help almost every client with the 250, and then we just try to end it there. We don't have to take on cases. Again, it's adjustment of status. You could probably do it yourself. However, if you really want to, we list our prices online, right? So our website, you could take a look. That's the basic fee for most cases. After the consultation, once we know your situation better, we can give you a more direct quote. But again, it's not our goal during the consultation to sign in cases. It's our goal to help you so you know how to do it. And again, this is free consultation. It kind of, sort of, in these live conferences, you don't necessarily have to hire a criminal lawyer, a criminal immigration attorney to help analyze the situation. ChatGPT, Gemini can probably do a pretty good job. Upload your situation and ask, is this inadmissible? Can I still get adjustment of status? Whatever your answer is, probably 80-90% correct. Ask for citations, of course. Again, that's because you're saying it's a misdemeanor and got dismissed, right? So there's a lot of exceptions for a misdemeanor. And if it's only one.
And always check the citations they give you too.
Yeah,
right?
because ChatGPT does hallucinate. So ask for references.
Yeah. So this is a follow-up on the backlog question. I'm waiting on my EAD, but there's no time frame. I had an RFE. Would that affect things?
It's quite unusual to get an RFE for EAD, so that is a cause for concern.
How could someone adjust their status after advanced parole, legal entry, without marriage?
Your parents are U.S. citizen. Your children are U.S. citizen. That's over 21. Right? So as long as you have lawful entry and you have immediate relative that can petition for you, that can waive, then you can adjust. Let's say they're green card holders and they're petitioning you. Then you could maybe do a waiver, right? But the easiest is obviously if it's your parents, your children, or your spouse.
Oh, the RFE wasn't for the EAD, it was for the I-130.
Oh.
But will the RFE now affect the EAD?
We are beginning to see this. Let me give you some context and background. A couple years ago, and all the time before that, when people file I-130, I-131, 765, and which is the EAD, and the I-131 is adjudicated by contractors. They're not immigration officers. It's just a processing. They just pump it out. The government didn't like that, and so they're pulling the power away from those contractors. They're saving money or whatever. I don't know, but no more contractors. Now it's the immigration officer adjudicating all these. Now they're still pumping a lot of these I-131s and 765s out and processing them if they don't see there's a problem with the I-130 or the 45. But if they do see a problem with the I-130 and the 45 and they're issuing a request for evidence, then they're holding back the reentry permit, their advanced parole, and they're holding back on the work authorization because a lot of people have tried to game the system. Even though they don't qualify for the I-130 and they don't qualify for the 45, they know the processing time for the I-130 and the 45 is so long, 9 months, a year, that they just, pay the fee, file the case, and maybe they get an advanced parole, maybe they get work authorization, and now they can work for a couple months, and they just consider it a quote-unquote subscription, and so they just, do that again. Maybe the I-130 and 40 have been denied multiple times, but they just go around and refile it again, just so they can get that advanced parole, just so they can get work permit. So, is it a cause of concern if your I-130 got a request for evidence? Maybe, maybe not. They are taking long. I-131s and 765s are taking maybe 6 months, 8 months, So,
will the RFE on the I-130 affect now the EAD? Like how long they take to get it?
Yes. So, if the officer is suspicious about your I-130, they're probably suspicious about your 45. They're probably not inclined to want to approve your I-131 and 765 fast. That's why it will affect it.
My fiance didn't get her work permit because USPS said they got it delivered, but she never received it.
That sucks. We have to reapply.
Reapply?
Yeah.
Hey, Joseph, I had a consultation with you a few months ago for abandonment. I'm now in the National Guard.
Congratulations. I don't quite remember. You're part of the National Guard now. So did you abandon or did you not abandon? But yeah, I'm very happy for you.
She waited and sent paperwork to replace the work permit, but still no answer.
Yeah. USCIS makes mistakes all the time. Yeah, keep on pushing, right? Use Emma, use the phone, Yeah.
Okay, now I want to jump back. Oh, I was the one who spent 15 years abroad, and they re-entered and are now in the National Guard.
Wow! Out for 15 years, you came back and you're part of the National Guard. Congrats. That is very difficult. That is a new record. I'm not going to claim it as our own, right? Obviously, because we didn't prepare the whole case. Our record is still out of the U.S. for 13 years. But if you did a consultation and you got it and you came back and you left the U.S. for 15 years, so happy for you.
Yeah, that is amazing.
That's crazy.
How are I-129F applications looking?
From my perspective, it's still the same. There's not a huge amount of crackdown or changes on that front. It's always been long and difficult. But with that being said, a new statistic that I've learned sort of internally, so take it with a grain of salt, but internally with USCIS, supposedly I-129K visas, more than 80%, 90% is filed by individuals without the help of law firms. And so if you do a good job in preparing it, you might be adjudicated better, right? So all the difficulty and bad rep around K visas, well, it's because a lot of them are just pro bono. Everybody's doing it themselves,
So how can I book a consultation specifically with you?
Go online, our website, and book the consultation. If you only want to talk to me, it doesn't matter then. Just pick any of the languages and book it, and just put in the notes you only want to speak with Joseph for whatever reason. And then let us know your time slots. Then we'll reach out back to you to kind of coordinate, right? Now, my slots are, very limited. I'm trying to help as many people as I can, but I can only do so much. And Thanksgiving's coming up, holidays are coming up. And so if I'm not available and you only want to speak with me and it just doesn't work out, we just refund you, right? Again, we're not here to try to make money off the consultations.
Now, you said try Emma. This is for the
yes.
Almost, like, and the phone and stuff, but her permit is almost expired. So what does she need to do?
Then the next step, if it's really urgent, go to the field office, even without an appointment, and go and be that persistent widow, right? Again and again. What is a field office? Just look up USCIS field office. You'll find the local offices near you. And traditionally, they have been understanding if there's an emergency situation, explain why your situation is emergent. Normally, they will say you have to schedule an info pass before you could come in. Well, it's an emergency situation. You tried to contact, you couldn't. Show up, explain the situation, see if they can help you out.
Is getting your congressman involved with your case the fastest way to push the I-130?
Is it the fastest way to push your I-130? All right, if you really want to talk about theory here, I've read that it is possible to get the courts and the embassies to adjudicate the I-130. It's like extremely rare. But for them to say, this case is so bizarre, so urgent, so important, we will just pull it, we'll adjudicate it ourselves, sign it, prove it, stamp it, boom. We skip USCIS entirely. If you want USCIS internally to pull it and say it is urgent, you need a really, really, really powerful reason, such as U.S. is pulling troops from Afghanistan, and so they want to expedite all the I-130s of people who are in Afghanistan. That was a direct order from the White House, and so USCIS has to listen to a government official. If it's just a congressman, a senator, even the White House writing an email to USCIS, hey, why is this case taking so long? If it's just that, they routinely just answer, sorry, that's just processing now. And it's on the normal course of things. Nothing is unusual because USCIS is just slow. So if you have a super urgent situation, you really want to escalate it. But it is extremely hard. I'm just saying, it's extremely hard to escalate I-130s.
Okay, we'll answer two more questions super briefly. May I ask, how much is your consultation fee?
$250. We are going to raise it next year. Haven't decided exactly how much. It's going to be all the partners deciding that.
How does DACA stop you from getting deported?
How does DACA stop you from getting deported? Well, let's put it this way. If you don't have DACA and you entered without inspection and ICE stops you and they check and you don't have status, or your visa expired, right? You're in the States unlawfully. They detain you, they put you through expedite removal, and now you're deported. If you have DACA, you show ICE, hey, My life is here, my work is here, my family is here. The U.S. depends on me. I have DACA. Can I not be deported? Most ICE situations will say fine, right? They won't even book you in. Now, obviously, if you have criminal records, if you have other things that make you a public threat, a nuisance, then they can still deport you.
Okay. Permanent. Oh, I filed for adjustment of status. I see an A number on my USCIS account. Does that mean anything?
Yep. Now you have a file number. So now you officially have an A number, and that A number will never change. It is always with you. Unless you abandon it and you have to apply for SB1 or apply for a green card again, then you'll get a new A number. But until, this A number is forever yours.
Permanent resident married someone who overstayed their visa and wants to start the green card process now. Is there any tips?
You file the I-130 so you can establish the marriage. And if you become a U.S. citizen, then you can upgrade that petition and they can adjust status. Great. Don't need to apply for a waiver. If for whatever reason you as a green card holder cannot get a citizenship, for whatever reason, there's a lot of people who can't, then you can file for the waiver. And it's called the 601 waiver, 601A waiver. Look into the extreme hardship. You really have to tell a good, compelling story why without that person, your life will be in shambles. Today's success story is about a high executive from Canada who is here in the United States on an L1 visa, and they are applying for the green card to be an executive manager in the United States, and they deserve a green card. We do a lot of these cases, and we found out in this April that their case was denied. Another firm helped them out last year, filed the case, got a request for evidence. They responded to it. The case got denied during Christmas time. They found us, did a consultation, retained us in April. We prepared the case together. We filed it within like a month, got a request for evidence, responded to it, and the case got approved, and now they can adjust and get a green card. Let's walk you through this because this entire process has been pretty bizarre. First of all, they are already on L1. They already proved a lot of things, right? So L1 and EB1C, the requirements are almost identical, right? And so a lot of people might think, I don't understand that. To get an L1 visa, you need to prove that the two companies are connected, and they got the L1 visa. Now you're applying for EB1C to get a green card. Why do they go back and challenge that these two companies are not related? That's bizarre. It's almost like dating, right? You're in a relationship, and the girl or the guy says, I love you. We're in a relationship. But then they say, no, I don't love you anymore, so I'm going to deny your proposal. I guess you could say, well, I love you enough to be in a relationship. I love you enough to date you, but I don't love you enough to get married to you. Okay, that's what L1 and EB1C is like. I approve your affiliate relationship between the U.S. company and the Canadian company, but sorry, on EB1C, I don't think that relationship exists. It's frustrating, but that's why the case was denied on one point. The second point in which it was denied is because they don't think the U.S. company has enough finances to pay this executive their salary. What? It's a huge Canadian company. It's a huge U.S. company. They have products all over the U.S., but the USCIS denied it, saying you don't have enough finances and we don't accept the documents you submitted to prove the two relationships. We refiled it. We provided a lot of documents to argue for both of these, and it got approved. I think the best way I could help and explain everything is to just go through the denial notice. So I have here the request for evidence that was sent out in August, and I have the denial notice sent out in last year. Oh wait, no. Oh, here it is. Here it is. The denial notice was in December last year. So this is what they said. These regulations, together with the case law, confirm that ownership and control are the factors that must be considered in determining whether a qualifying relationship exists between the petitioner and foreign entities for purpose of this classification. The petitioners claim that it is an affiliate. They provided this and this and this, but it is insufficient. And then on the ability to pay issue, which is the newest way USCIS is denying EB1C and L1A cases. Before, they used to deny cases saying, oh, you don't have enough managerial or executive duties. This petition category, EB1C, is only for executives. You're a first-line supervisor at best. But now they use ability to pay. So ability to pay may be established in one of three ways. The petitioner has a net income equal or greater than the proffered wage. The petitioner has net current assets that are equal or greater than the proffered wage. The petitioner has already been paid the beneficiary at a rate equal or greater than the proffered wage. Counsel, so this was last year, right? The prior law firm and the petitioner, they relied on bank statements that this case, and they said that is not sufficient. You cannot rely on bank statements, and they go through and explain why bank statements is enough. And so they ultimately denied the case. In our refiling, this was the strategy, right? So we refiled it in June of this year. We showed the financial achievements and positive outlook of the company. I have to be really careful. I don't want to put the client's information out. We showed that the company made over $1 million. We showed that the assets is over $1 million. We showed that they're in early stages, they're heavily investing. And we talk about the business plan and how they're going to be successful. We submitted 6 exhibits to prove that. You know what? I'm going to go through the exhibits to kind of show, right? So for the financial ability part, we showed, oh, wow, this is so much. Okay, it's just too much for me to read. There's like 30 exhibits. All right, so, but just on the financial positive outlook, we submitted like those 5, right? And then we showed that the company is related to each other and the qualifying ownership. And so the stocks, the notarization, the company was incorporated in Delaware. It's a very complex company structure. So we were working with their counsel very, very closely. Grace and 2 teams, by the way. Grace was leading, and there was 2 teams that worked on it. One for the initial filing, and then one for the request for evidence. Because when the request for evidence came, it was sufficient with the financial part, but it wasn't sufficient on the corporate ownership part. And so another team came in for the corporate ownership part. All this is to say, USCIS is becoming much more strict. They're finding new ways to deny cases that wasn't done before. And so unless you do this a lot and you can really push back and say, this is the law, this is the requirement, it is not necessary to provide these things. And even if it is necessary, the evidence that's required, the standard is preponderance of the evidence. You want one thing, we don't have it, we give you 10 other things. You should be able to prove it. And if you don't, it's a prejudice and it's discrimination. And so we hit back hard. The case was approved. EB1C is one of those things where a lot of people think, if I got my L1A already, it should be easy peasy, but it is not. USCIS have such a higher standard. They want so much more. They look so much more deeply into the case. And so the worst part is if your L1 wasn't filed up correctly, even though it got approved, it could be denied on the EB1C front. And now you have to redo everything. We actually had to redo a lot of stock certificates, by the way, right? And so we had to go through Delaware attorney office. We had to go through Canada. We had to bring in the corporate counsel, and we had to just amend a lot of things because just it wasn't done correctly. But luckily, USCIS accepts these corrections and was finally able to approve the case. Shout out to Grace and her 2 teams, and the business development team. John was very much involved with this as well. If you guys have any questions about EB1C, happy to help and explain. But like I said, we predicted this even a year ago. Ability to pay is their new way to deny a lot of cases. So you gotta solve that problem.
Okay, thank you, everyone. We will be live next Wednesday.
Yeah.
On Thanksgiving. So we will see you then.
Take care.
Bye-bye. Bye, everyone.